Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, they're holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for
Hello, everybody. I hope you're doing well. This is the first time I'm hearing myself talk. I do sound a little bit sick. I feel a little under the weather, but I took a pill just labeled daytime, and things are moving in a slightly alternate dimension at the moment. Anyways, I hope everybody's doing well. We have some small claims court to watch, and I'm remembering what buttons to press, so that's a good sign. I also have a new strain of weed called Blue Iguana, which is 30% plus, which is really sweet. So, you know, maybe it's a combination of both. Courtney's gonna do dishes. Good job, Courtney. Yes, Bev, it is going around. Let's hope that it's a blip. It's a blip on the radio. Ugh. I also just had a really good idea, but we can't talk about it yet because I have to vet it. But I gotta write that down. And we're gonna listen to the judge. We're gonna go to court. Everybody's gotta be on their best behavior, even though I'm only wearing a sweater and no shirt. I just realized. I'm like, oh, well, whatever. We are going to court. Everybody's on their best behavior, okay? Small claims court. Any one of us could find ourselves in small claims court for one reason or another. If you live in Thurston County, we might be able to watch you if it happens.
Answer, Natasha Kiyanaga. Okay, no answer. All right. Iris Rodriguez. Joel Espinosa, I see you logged in here. Thank you. And Mindy Dunn as well. Steve Fulton. All right. Sabrina Reed and Jeffrey Powell. No. All right. Juan Loya Ramirez. No. All right. Gianna Viana and Caroline Coomer. Okay, no answer. Raul Cortez. All right, sir, in the courtroom. And representing the reserve at Lacey, that's Ms. Freund. Good morning. Okay. All right, it looks like I just have one case with both parties present. I want to make sure I didn't miss anybody. Did anybody not hear their name who expected to be called? Okay, I guess I do just have one case with both parties present. So that's Mr. Cortez versus the reserve at Lacey. Okay. All right, has anybody else tried to log in or check in? Okay. Okay, got it. Okay, then I'm going to explain to you, particularly Mr. Cortez and the reserve at Lacey. We have mediators here today from the Thurston County Dispute Resolution Center, and they are going to help you to mediate a resolution to your case. Okay, so I'll explain to you here why we have this service. People who come to small claims court, we've found, are more satisfied with the result that they get in small claims court if they mediate a resolution to their case themselves. with the help of the Dispute Resolution Center mediators. There's a number of reasons for that. I'll tell you what some of those are. People who come to small claims court often have expectations that can go unfulfilled because maybe you aren't familiar with small claims court, or legal procedures that are sort of built to resolve disputes in the context of a court trial, as opposed to you resolving your dispute yourself. When you resolve your dispute yourself, you can take into account things and make provisions in your settlement that the court can't do for you. Okay, so when the court hears your case, what I will do is I'll hear from the plaintiff, I'll hear from the defendant, and based on the evidence I hear, testimony I hear, I'll make a decision as to what facts I believe have been proved. And then I'll apply the law that applies to your case. That could be in a lot of contexts, things like, liability and automobile collisions or contracts. But in your case, it sounds like it's going to be a landlord-tenant thing. Apply that law and then give you a result according to what the law says as I see it. Now, I can't do a lot of things, though. I can't take into account things that may help you get your case resolved, like a compromise, right? You may have a compromise as to what amounts are correct or something like that. I can't compromise for you. All I can do is find the facts, apply the law, come to a result. Another thing I can't do is set up a payment plan or, make somebody pay over time. If I find for a plaintiff, I'll issue a judgment, a money judgment. It's a piece of paper and it says one party owes the other party money, and that's what you get. That's what you leave small claims court with. And a lot of times people come to small claims court, they prove their case, I find in their favor, and issue a money judgment for a certain amount of money. And I hand them that judgment, like I said, a piece of paper, number on it. And the first thing they ask me is, where do I get my money? Now, you don't get your money here. The small claims court doesn't pay the judgments. You have to collect the money if you win a judgment. And that means entering into another legal process. And that legal process does not happen in small claims court. It's a separate process, and it may be something you're not familiar with. So you may need help in order to collect a judgment, which means you may have to pay a lawyer. You may have to end up spending more money than your judgment is worth in order to collect your judgment. So keep in mind that there are things about small claims court you may not have known coming in here, that things that you might find unsatisfying or frustrating. And in the example I just gave, that's even if you win. Now, when you go into a trial in a small claims case,
When you go into a trial in a small claims case and MPC donates $10, you say, thank you. Thank you, MPC. That's so sweet. And gifting. Yay! I clicked the wrong button. I got so excited. That's so sweet. Thank you so much. I love it. I love it. I love it. And welcome all to our new members. Wow. Thank you. That is so sweet. Okay. The judge is trying to convince these people not to go in front of him, by the way. I always think it's the funniest thing. Because he's basically doing his best to be like, don't get before me, because I can't really make compromises. I can't enforce payment plans, things that you can agree to do, but small claims court can't do. You guys are the best, by the way. Thank you again, MPC. Amazing. Also, is that a mirror above Iris's shoulder there? Or a lookout sort of window painting? Is that what that is? And Casey Carey, so sweet.
keep in mind too, that I'm going to hear from two sides. Okay, there's always two sides to every story. There might be more than two sides, but there's at least two sides to every story. And most people who come to court think that the judge is going to believe them and accept their version of the facts, and then not believe and not accept the other party when they tell their side of the story. Now, that may not happen. You got to keep in mind, if you're thinking that, the other party's thinking that. And it's totally possible I might believe their side of the story, or I might believe part of it, part of yours, part of theirs. And then that affects how the case goes. Okay, that might affect how much the case is worth or something like that. Another thing to keep in mind is that the law may be different than you think it is. A lot of people, they know the law, and especially if they do business in an area of the law and do it all the time, they may be very familiar with the law. But a lot of people aren't. That's part of what small claims is for. And they may be surprised. Sometimes people come in here and they think they know exactly how the law applies to their situation based on their own understanding. And then when I apply the law, it's different. And if the law is different than you think it is, that is absolutely going to affect the outcome of your case. So when I tell you those things because I want you to keep it in mind when you go into mediation and resolve your own case. That prevents those kind of surprises. That prevents those kind of things happening that you don't expect. You have control in mediation as to how your case comes out. Now, you may not get everything that you want. That happens in life, but you may get what you can accept and what you're comfortable with, what you can live with, that you can leave here, you can go home and feel like you got something worthwhile out of this that makes sense for you. So in a minute here, I'm going to turn the courtroom over to the mediators so that they can mediate the case with you. And then when they're doing that, once we've got everybody settled into mediation, I'll call the cases for the other cases where there's only one party present. We'll deal with those. When you're in mediation, please just the mediators would like for it to be just you, just the parties, not any friends, witnesses, support people, anything like that. And then they will take it from here. But I'm going to ask you as you go into mediation to please keep an open mind and go into it with an earnest desire to reach a fair resolution to your case. And I wish you good luck in mediation. So I think it's going to be Leslie who's going to talk to you. So please give your attention to Leslie from the Dispute Resolution Center, and I will step off the bench while she takes you into mediation.
Yeah, we're not going to watch that part. Guess what? Didn't work. Leslie, you fucked up. You didn't do it. You didn't do it. You know why? Because here we fucking are with a real case.
All right, this is case 38007. All right, and so I'll just give you a brief description about how the case will proceed, and then you can get started. So what I'll do is I'll swear the parties in, and then Mr. Cortez, you're the plaintiff, so you get to go first. You'll present your case, which is you'll explain to me why it is you believe that the reserve at Lacey owes you money. I'll hear your testimony, consider any exhibits that you point out to me, and I don't know if you have any witnesses, but if you do, then they would be able to testify. After you've had a chance to present your case, then it'll be Ms. Freund's turn to present the case on behalf of the reserve at Lacey. Same thing, just hear your testimony. You can point out any exhibits that you believe support your defense, and if you have any witnesses, they can testify as well. After I've heard from each of you, I'll make a decision, and I will also explain why I made the decision that I did. During the time the other party is telling me their side of the case, I'm going to ask you to please don't interrupt them. Just let them tell their side of the case. Keep in mind that, even if you hear something you don't agree with, that you either will get your chance to tell me your side of it in a minute, or you've already told me your side, so I'm aware of it. I may need to ask you questions from time to time, just to make sure that I understand what your claim is or what your defense is. Also, I may do that just to keep everything focused on the facts and issues that I think are going to help this case get resolved and sort of keep us on track. So, all right, with that in mind, then I'm going to have each of you raise your right hand, please. And do you each swear that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, all right, Mr. Cortez, you are plaintiff. Go right ahead, sir.
There on October 30th, I signed a contract with the Reserve Basic to rent a one-bedroom apartment. The rent was $889.
Mhm.
I put my application.
$889. Oh. 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 I wish my rent was $888 or whatever he said. Hi, Miss Carrie, by the way. Nice to see you. Yes, sir. Speak up. Sir.
Because I did not have a rental history. They increased the deposit to equal 1 month rent.
So your deposit was also $889?
$889.
Okay.
I don't have my contract here with the public yet.
Was it 889? Okay, I may already have it. Let me see.
You have just a front page, but this is the entire contract.
Okay. Second here, I'm opening up your, the exhibits that you
Bottom
filed.
right-hand side, section
Mhm.
4, it says deposit.
Oh, you only see, okay. Just a minute here. I want to make sure I'm looking at the same thing you've got there. So for your exhibits here, all I see submitted are pictures. Maybe I haven't scrolled down far enough. No? No, I don't see it. Okay. Yeah, why don't you let me take a look at that real quick then? It could be that the reserve submitted it, sure.
And the deposit is right there.
Okay, so this is your lease and the deposit amount is written here and it says $889. Okay. And okay, but your claim is for more than that. You want $1,871.56.
That's correct.
Okay, I guess you'll get to that. Okay, and here's the part where it says your rent is $889 a month too. I see. Okay, why don't I let you take this back then so that you have it. There you go. Okay, so what happened that caused you to believe that the reserve owes you $1,871?
How I came up to that amount, was the rent is, the deposit is $889.
Mm-hmm.
I have here my receipts for monies that I spent on trying to contact them.
Okay, you didn't submit any of this in advance?
This is in the file, but this is the original, if you like to see that.
Okay, I don't know why I don't see those in here. Maybe I'm looking in the wrong place. Maybe they got filed under somebody else's exhibits. Okay, so what is it you're wanting to show me there is?
What I paid the post office and the return receipts that they serve the letters. And I have to do a second reply based on what they reply. I replied to that. And I replied to both the real estate company that manage the building and also to the reserve leasing office.
Okay, so that's cost of mailing.
Right, that's cost of mail.
Okay, and how much was that?
As well, that would be, the first time was a total of $16.10.
Mm-hmm.
And the second time was a total of $17.46.
Okay.
Plus the court cost.
Right.
Plus $50.
Mm-hmm. That's your filing fee.
Yes. I did, you like to have, I did file this copy there.
Is that the copy of your filing fee?
Yes.
Yeah, I already know that.
Oh, okay.
Yeah, that's the same for everybody.
Okay. And so how I came to this, Your Honor, is I moved out of my reserve on June 30th, 2023.
Okay, so the move out date was June 30th, 23.
2023, yes. Sir.
Okay,
When I moved out, I um, have a receipt here. That move out, that is signed, receiving the apartment back.
Mhm.
Plus, I filed all the pictures of the unit,
right,
of the condition of the unit when I moved out.
I do have that.
Um, At that time, Your Honor, I had received my last power bill, which was like $105. And that was through from mid-May through mid-June.
And
So I
that
left a
was,
couple of weeks of June that I have not received anything. And they were wanna bill me for that.
okay,
Um,
that was your bill to the power company, or how did that?
the power, the water in the sewer was
You-
paid to a third-party company
Yeah,
that managed the reserve bills.
mhm.
So at that time, I waited. The end of July came. I didn't receive anything.
When you say you didn't receive anything, what is it you were expecting to receive?
I
that
didn't
you
receive
get?
a bill. I didn't receive a disposition of deposits.
Oh, from the deposit.
Right, from that.
Okay,
Yes,
so you were expecting to get a final accounting of your deposit from the reserve,
correct.
and you didn't get that
No.
ever, or?
I didn't get it.
Okay,
So I waited until mid-August, because I figured if they mail at the end of July, maybe give them a week or two for the mail to deliver it.
mm-hmm,
By mid-August, I have not received anything. So I called the reserve and I got an answering machine. I left a message. I left 3 messages and I never received a reply. So I got some legal advice and they instructed me to send them a letter, which I did. They replied to the letter, but by this time it was over a year later. They replied to
Year
the
later?
letter, and on that letter, they sent me a disposition of deposits.
and that was a year after you moved out?
Yeah.
Okay.
And it took kind of long because I didn't know how to go through that process. So I went and got legal advice and help on what to do and what not to do. I received a letter that they sent me, and on that letter, they put the disposition of deposits.
Mhm.
However, they didn't show my deposit of $889. When we went to mediation, she was trying to explain something to mediation that didn't make sense.
You don't have to tell me about mediation.
I made my deposit. I paid for the 2 days rent for the month of October. I have the records. I paid over $1,300, which was 2 days rent in the deposit. Then after that, they had a incentive,
They had a what?
an incentive
Oh, an incentive.
of $1,000 if you move in with that amount of time. So that covered my December rent. And then in January, I had to start paying rents, of course. When I went to the reserve, after they told me that I was approved to move in, right here on my contract, they gave me this letter that shows the incentive, shows the deposit, shows the rent.
Incentive and deposit, and then the monthly rent.
Yeah, and then I asked them how much I needed to pay in order to move in. They told me in order to move in, you have to pay the deposit of $889. If you don't pay the deposit, you don't move in. So I paid the deposit. I paid the 2 days rent. And I never received a letter disposition of deposits about my deposit of $889.
Mhm.
That I have never received up to date. I've never received that. For that reason, I'm asking for the deposit, the fees that I pay, and I was told that I'm allowed by law to ask for double my deposit, and it's up to the court to grant it or not. I did specify on my letter the laws that cover, the amount of time to pay to receive the deposit and the law that is paid about the double deposit. They're charging me some fees there, but I never received that letter charging me those fees. So according to the RCW law, they have 30 days.
Mhm.
They cannot charge me.
Okay.
And that's what I'm looking for.
So you moved out June 30th of 2023, and so you are saying that if that's the case, you should have received the disposition of your deposit by July 30th of 2023.
Yes.
Okay.
This is my move out,
That, yeah, okay.
which is signed by Kelly.
I know I have that. Yeah, here it is right here. Yep, says June 30th of 2023. Mhm.
And with that, I also have my 30-day notice.
Hmm.
And I also file my walkthrough inspection at the time. The pictures show that I'm
And that's what the pictures are for. Show the condition of the place when you moved out.
correct.
I saw those pictures that you submitted. I have them right here. All right, Mr. Cortez, is there anything else you feel like you need to say that you weren't able to say before I let Ms. Freund tell me her side?
Not at this time, maybe after she.
There's not going to be an after. So if you're holding anything back, tell me right now, because there isn't going to be another time unless I need to ask you a question.
Just the fact that I didn't receive anything within the 30 days.
So I think just to make sure I'm clear, because I don't want you to miss something that you meant to tell me. The nature of your claim is that at the end of the time of your tenancy, when you terminated your tenancy, which was June 30th of 2023, within 30 days after that, you didn't receive any notification of the disposition of your deposit. And you didn't receive anything in response. You didn't receive anything on that issue until a year later when you sent a letter to them. And then the amount of money that you're claiming is your deposit plus your costs plus your filing fee, and then potentially the doubling effect of the deposit based on the statute. Okay, did I sum it up correctly?
Yes, sir.
Okay,
Thank you.
okay. All right, so let's go to Ms. Freund then, and let's hear the reserve at Lacey's side of this. Ms. Freund.
Good morning. It's just pretty simple. I wasn't the manager when Raul moved out. I have worked at this property since it opened up though. So I was there. I just wasn't the manager. I have his move out statement here and his ledger and all the paperwork that was sent to him after he moved out on July 3rd, 2023. I didn't hear from Raul again after he moved out until his certified letter came, which I immediately responded to with a letter and copies of all of his move out stuff that I make copies of and sent to him. They're all dated July 3rd, 2023. This isn't something that, was backdated or whatever. It's just printouts from our computer system. Has a move out statement, his full ledger, the biggest charge that he was charged was his utilities. Looks like he had a previous balance of $320.25 that was due, and then hit the current charges, which would have been from the last time he got billed, plus they're about a month, a little over a month in arrears when they received their bills, so it would have had the additional time on there. So he has a total amount due of $556.84. This was also turned over to collections. So he's also been hearing from the collection agency for payment over the year. So I did double check the address. His move out receipt does have the same address that he's sending from the certified mails.
Hold
So
on,
it
ma'am.
was
Hold
mailed
on.
to the correct.
You can't keep the money and say that you've used it for that, and then he's still going to collections for it. I thought she was explaining that they used the deposit to pay this bill. That doesn't make any sense.
Address.
All right, let me ask you then, pertaining to this exhibit regarding the move out statement. The one that's entitled move out statement. The date on that in the upper right corner says July 3rd, 2023. Can you tell me if you know when was that sent to Mr. Cortez?
They're sent on the same day. So I wasn't the one that did this move out, but it's a pretty simple routine process that we do on, a lot. So you just stick it in an envelope. We have a stamp machine sitting right by the office or right by the desk. So it's a pretty simple process.
So that's done the same day as the date on it?
Yes.
All right. And then according to this, and according to your interpretation of this, the disposition of his deposit, did he get any of it back?
No, he still owes $535.34, which is the amount he was sent to collections for after not receiving payment. Also his deposit. So his lease does say his deposit was supposed to be $889, but the reserve at Lacey only received $300. I did give you a full printout of his ledger since move-in, and you can see that he's only paid $300 towards his deposit. So that is the amount that he was applied. It was applied to his move-out expenses when he moved out.
And that utility bill is the one that it's a little bit small, but I think it says $556.
Yeah, and 84 cents. 84 cents.
All right. I see what you're saying there. Okay. And that was sent to, let me see here. I guess that's the part I need to ask next is what address was that final accounting sent to?
It's on the accounting statement as well as his move out receipt. It's P.O. Box 5950, Lacey, Washington, 98509.
Okay, I see it here on this move out receipt. And let's see.
That's the receipt. That just means that's what we sign with them. Then when we get the keys back and they give us their forwarding address on it.
Okay. And then it looks like that same address is printed here on the exhibit that's entitled Notice to Vacate.
I'm sorry, I'm on vacation, so I'm kind of a mess right now. Yeah, his
Carrie.
notice to vacate has the same address as his move out receipt.
Not Miss Carrie, but that's
All right.
Carrie.
So as far as you know, his last known address was that P.O. box in Lacey.
Yeah, and I did check when I received a year later, I received a certified letter, and my first thought was maybe it was the wrong address, but it's the same address as he was using then. So I'm assuming it's still the correct address. I don't know.
All right. Trying to see if I have any more questions for you regarding that. don't think I do. So
Hold on though. She wants us to presume that they follow all the procedures perfectly, like she said, but that they let him move in without paying the full security deposit. I don't think those go hand in hand. If they follow all these procedures and send things out the exact same day and do all this accounting for it, it seems more likely that they wouldn't let somebody move in without paying the full deposit. That's the whole point of the deposit.
do you agree though with Mr. Cortez that well, he says that he moved out June 30th. You said he moved out July 3rd, just the difference of a couple days. Is that what
No,
I'm
he
hearing?
moved out June 30th, but July 3rd is the day we did his move out,
Oh, you did the
the
actual,
paperwork. Yeah,
I interpreted that wrong when you said
I'm
July.
sorry.
Okay, so everybody agrees June 30th was the termination of the tenancy.
Yes.
Okay. All right, Ms. Freund, is there anything else that you feel like you need to tell me before I make a decision in this case?
I don't think so.
All right, thank you both. Okay. All right, now, in deciding this case, keep in mind a couple of things. You know, I've obviously heard two different sides here that are very similar but slightly different. I have to decide the case on the preponderance of the evidence standard, which means the greater weight of the evidence. And the burden of proof is on the plaintiff, that's you, Mr. Cortez, to prove by preponderance of the evidence the substance of your claim. In this case, I think obviously broadly you agree between yourselves as to the relevant dates, and for the most part the amounts. I think the difference in your testimony regarding the amounts that has to do with how much of the deposit was actually paid. Mr. Cortez says it was the $889, which is the amount on the contract. Ms. Freund says it was collected at $300 in the ledger and the balance wasn't collected. So that's sort of the difference. I don't think that difference is going to make any difference though in how I decide the case. I'm finding in this case that the reserve at Lacey, based on the records that they've supplied here, the printouts of the records, and Ms. Freund's description of the process by which they process the final move out documents and financials and send notice, that I'm satisfied that that did occur. And that the address that was provided in at least two different places by the plaintiff was used by the reserve at Lacey to provide the final accounting, which is what's required under the statute. So the upshot of that is that the final accounting of the deposit was properly provided, and that the finding in this case is in favor of the defense, the reserve at Lacey. All right, well, that'll be the judgment of the court.
Your Honor, but they charged me this money. They paid over $1,300 to me.
Okay, yeah, Mr. Cortez, I heard your case, and that is my judgment, and those are the reasons for it. All right, I'm writing up that judgment here on a court judgment form, and both of you will be able to have a copy of it. File it with the clerk now, and Mr. Cortez, since you're here, you can have a copy of it right now. Ms. Freund, you can get a copy of it from the court clerk at any time.
Okay, thank you.
All right, you're welcome.
Do I just go?
Yeah, you're free to
Get back to
go.
vacation.
Okay, you have a good day.
Thank you.
Back to
And that'll
vacation,
complete
lady.
our small claims calendar.
I'm gonna get receipts at the time of things.
Wow. Roller coaster ride. Wasn't that a roller coaster ride, you guys? Oh, did you hear my chest? I sound a bit congested. I'm sorry. that's that. We're going to call it there. I have no wherewithal to find more court for us to watch today. That was an interesting case. I sort of wish we could have heard him better. I wish that he had a lawyer that had the receipts. Bring receipts, people. Bring receipts to court. File them first, you know? That's what I would say. But in the meantime, thank you so much for being here. It's Friday, right? Is it Friday? Tell me. Watch. It's Friday. Friday. Bill. That's hilarious. Through the matching bracelets. I love it. Oh, you guys are great. Anyways, listen, Sunday, members only, and we'll have 2 shows on Sunday for sure. I think tomorrow we are on our own. So enjoy the weekend, and I will see you on Sunday. Do me a favor, remember that I love you, and I'm proud of you, and I will see you in the next video. Okay? Bye!
Ways down and ready to ride.